series, we aim to kind of trouble the concept of law, the law's role in society, in structuring our lives, in the way that we can use it as a tool, or in the way that it acts as a limiting force on what we might want to do around particular issues. And so today, we're here to talk about some environmental justice issues. The topic today is, does the law indeed have green fingers? And so we've invited our colleagues here to talk about their strategies from the Centre for Environmental Rights, their strategies around litigating for environmental justice. So a couple of quick housekeeping things. First of all, the session will run until 2:15 to allow us to some extra time for questions. For those of you who might need to, is there anyone who would need to leave at 2 o'clock to go to a class? Okay, so you're seated in a good place for that, so feel free to leave at 2 o'clock. That would be great. There is lunch for anyone who hasn't got yet. Please tweet. Our handle is @CLSUCT, and their handle is @CenterENVRights. So please use those and tweet for us. So we're going to have 30 to 40 minutes input from our guests, and then we're going to move on to question and answer and discussion. So to introduce our guests, our speakers are from the Centre for Environmental Rights. CER describes itself as an organization of activist lawyers who help communities and social organizations in South Africa realize constitutional right to a healthy environment by advocating and litigating for environmental justice. So we have the pleasure of having two of their team here today. Christine Riddell, like the wine glasses, which is how I know that. She joined the Centre as an attorney in May 2015 as the part of the Corporate Accountability and Transparency Program. She is an alum of the University of Cape Town. And then Tobeka Gumede was born in a very small village in KwaZulu-Natal, somewhere between Eshowe and Melmoth, and grew up in a township known as Kwamakuta in Durban. She graduated with an LLB from the University of Zululand. So we welcome you both, and we look forward to an exciting seminar.
Great, thanks very much for having us here today, and thanks to everyone who came through. So I don't need to do much of an introduction, thanks very much. So I'll just give a brief background to the Centre for Environmental Rights. So we're a non-profit company and a law clinic, and we're based here in Cape Town in Observatory. As mentioned, we're a group of environmental rights lawyers that work to defend our constitutional right to a healthy environment. We work across a number of themes or programs at the Centre. We have a mining program, a pollution and climate change program, corporate accountability and transparency, biodiversity and water. So we cover a range of topics, and we do some litigation, as mentioned, and we also do advocacy work and research. We have a great website. If you want to check out our website, it's just www.cer.org.za. So I encourage you to have a look at the end of this. And yeah, let's kick off into, does the law have green fingers? And I'm going to hand over to my colleague, Tobeka.
Thank you, Christine. I do have a tendency of speaking too fast, so if I do, you guys can just give me some form of indication, okay? Okay, so like Christine said, we advocate for the realization of Section 24 of the Constitution. This section provides that everyone has a right to an environment which is not harmful to their health or well-being. So, and it also provides that the environments must be protected for not just for us in the present moment, but for future generations as well. What does this right really mean? So in the years that I've worked as an environmental lawyer, people often ask me, like, what exactly do you guys do? Is it advocating for trees, plants, and flowers, things like that? But it's not just that, it's beyond that. The right is actually linked to so many other constitutional rights. For example, a right to health, a right to life and dignity, a right to sufficient water. Some of you might even remember an incident that happened sometime in 2014 where a community in Bloemhof in the northwest a lot of those community members were actually hospitalized because they drank contaminated water, and all this was because the people were supposed to deal with the infrastructure and ensure that everything was well with the water infrastructure did not actually do that, and some of the children actually died because of diarrhea and dehydration. So that is just a typical example of how Section 24 is actually violated and how it actually links to the environment, the rights to health, the rights to life, and the rights to sufficient water. So there are a lot of laws that are enacted to actually give effect to this Section 24 of the Constitution. Even though this is good because it covers a lot of the aspects of the environment, sometimes it does become a bit of a hindrance because there's so many processes that one has to go through in some instances. So Christine and I are just going to talk about some of the ways in which the law can be said to have green fingers and how it actually applies in practice. Thank you.
Okay, so before we can talk about whether the law has green fingers, we actually have to get out the starting blocks, and that is in accessing information. So sometimes it's very difficult for civil society organizations such as ourselves to access the information that we need to hold companies and the state accountable when they breach environmental laws. So we have a great constitutional right, which gives us a right of access to information. We have a statute in place which says this is the kind of information you can request, this is how you can request it. And that, in theory, is supposed to make it easy for ordinary citizens to get access to the information that they need to exercise their other rights, like the right to a healthy environment. But we see that in practice it's a lot more difficult than it is in theory. For example, the Vaal Environmental Justice Alliance, which was represented by the Centre for Environmental Rights, spent almost 10 years trying to get access to ArcelorMittal's environmental master plan. So that plan was a document that detailed what ArcelorMittal, what they had done in Thundervale Park, the scientific assessments they'd done, and their plan to remediate their environmental damage over a 20-year period. So you would think that a document like this should be accessible to the community that lives next to the plant, the community that is affected by their operations, but they refused to grant the community access to that document. So VEJA put in a number of requests using the legislation that I mentioned, and they requested this document from AMSA, and AMSA said no each time. And this left them in the position where they actually had to go to court to litigate on this issue. They had to ask the court to force AMSA to grant them access to this document. So now this is a very frustrating, time-consuming position to be placed in because of the company's obstinance and refusal to engage with the community. So the Centre for Environmental Rights represented VEJA in this case, and luckily all the hard work was not in vain, and we got a good judgment from the Supreme Court of Appeal. And the SCA said that the AMSA must give access to this document. They also said very, very hard-hitting comments about the dangers of a culture of secrecy and unresponsiveness. They berated AMSA for its obstructive, contrived, disingenuous approach. So AMSA had gone around in their annual report stating that they engage with the community, that they have all these wonderful programs that assist the community, yet they refused to give them access to this basic document detailing the pollution in the area and what their plans were to address that. So the judgment recognizes the importance of consultation and interaction with the public, and it recognizes that environmental degradation is something which affects everyone, and that's why it's so important that there's access to this sort of information.
So I'm just going to read out a few quotes that we found that were so important and useful in this judgment. So the courts went further and recognized the role that civil society organizations play. And it said, thus, a community-based civil society organization such as the applicant is entitled to monitor, protect, and exercise the rights of the public, at least by seeking the information to enable it to assess the impact of various activities on the environment, and like-minded individuals must be encouraged to exercise a watchdog role in the preservation and rehabilitation of our natural resources. It also said, the court also recognized the responsibility of corporations operating in South Africa. Corporations operating within our borders, whether local or international, must be left in no doubt that in relation to the environment, in circumstances such as under discussion, there is no room for secrecy, and that constitutional values will be enforced.
So our law is designed to ensure that development happens in a sustainable way, so meaning that social and environmental considerations are taken alongside the economic factors. But despite the legal requirements or the so-called green fingers of our law, we still see development decisions that are taken in a vacuum, decisions that are taken without considering the environmental impacts and without considering the ordinary needs of people. So before any development or new development can take place, it's likely that it will trigger what are called listed activities. And because it triggers those activities, it will have to do an environmental impact assessment. In other words, it'll have to assess all the impacts that the new development is going to have on the environment. So while these assessments are great in theory, and they require a range of factors to be taken into account, including that the developer look at all the alternatives of the project and go into whether this is indeed the best solution or the best development for the area, given all the factors that it must take into consideration, we often see that this is simply a box-ticking exercise. So the developers just going through the motions, they hire their own environmental assessment practitioner. So this environmental assessment practitioner is supposed to be independent. They're supposed to look at the environmental impacts completely independent of the developer and give a proper assessment of what impacts this development is going to have. But invariably, because the developer is the one that pays the environmental assessment practitioner, they see the drafts of the report, they have to comment on it. And what we often see is a very sanitized version coming out in these EIAs, saying that, you know, this is the best development for the area, all of the environmental impacts can be mitigated, everything's going to be fine, and it can go ahead. So let's talk a little bit about a particular environmental impact assessment. So the EIA conducted for Thabametse. Now, Thabametse is a new proposed coal-fired power station that they are planning to build, and in this EIA, they were supposed to take into account all relevant environmental factors. Now, one would expect that as part of that process, you would need to look at the climate change impacts of a new coal-fired power station. Given the state of the world and given where we are, if you're going to build a new coal-fired power station in today's environment, then you would need to consider what greenhouse gas emissions it's going to have, what impact is this going to have on South Africa's ability to meet its legal obligations in terms of the Paris Climate Change Agreement? All of that would need to be considered, one would expect. But it wasn't considered in the Thabametse EIA. But nevertheless, the Department of Environmental Affairs, and after that, the Minister of Environmental Affairs on appeal, granted Thabametse an environmental authorization and said you can go ahead and build this new coal-fired power station without considering any of the climate change impacts. So EarthLife Africa challenged this decision, and they were represented again by the Centre for Environmental Rights. And luckily we had a judge who saw reason and ordered that the minister must reconsider the appeal, and this time taking into account a full climate change impact assessment. So the company had to go back and they had to employ environmental assessment practitioners to put together a climate change impact assessment. And the judge said that this was part of the existing law, this was part of their duties under the environmental impact assessment requirements, that they consider these climate change impacts. So the judgment, in our view, is a huge victory, and it's going to have serious implications for the future of coal-fired power in South Africa. The judge clearly understood the purpose of an environmental impact assessment. I'm just going to read you a great quote from the judgment. So the judgment says, "The environmental impact assessment process is a key means of promoting sustainable development by ensuring that the need for development is sufficiently balanced with full consideration of the environmental impacts of a project." The judge also highlighted the risks that climate change poses to sustainable development, commenting that the effects of climate change in the form of rising temperatures, greater water scarcity, and the increasing frequency of natural disasters poses substantial risks. Sustainable development is at the same time integrally linked with the principle of intergenerational justice, requiring the state to take reasonable measures to protect the environment for the benefit of present and future generations. Short-term needs must be evaluated and weighted against long-term consequences.
Thanks, Christine. As mentioned before, there are many environmental legislations that were enacted to actually give effect to Section 24 of the Constitution. So I'm going to speak about one of those environmental legislations, which is the National Environmental Management Protected Areas Act. I shall refer to it from now on as NEMPA. Okay. So this act is primarily responsible for the environmental management of our protected areas. What are protected areas and what constitutes protected areas? A protected area could be a nature reserve, a World Heritage Site, or a protected environment, as declared by the MEC or the Minister. What is the purpose of declaring these protected areas? It could be anything from trying to protect the ecological integrity of the areas, to conserve the biodiversity of those areas, to protect South Africa's threatened and rare species, to protect an area which is vulnerable or ecologically sensitive. These are areas that have been identified as having some form of value or sensitivity that they need some form of protection. So one of the objectives of the Act is to promote the sustainable utilization of these protected areas. The Act even goes further and says that the state, which is the government departments, are mandated with implementing this Act and fulfilling Section 24 of the Constitution, and they are the trustees of protected areas. I will now discuss a little bit one of the cases that we have been dealing with at CER, which looks at how this particular legislation was actually implemented. And it deals with the Mabola protected environment. So sometime back in 2014, the MSc of Economic Development, Environment and Tourism in Mpumalanga declared the Mabola protected area. Why was it declared? It was declared because this protected environment falls within the Inkangala-Drakensberg strategic water source area, which provides water to the local community, to downstream users, and as well as the economic hub of Gauteng. The strategic water source areas were described in one of WWF's reports as being 8% of South Africa's land that provides 50% of our fresh water. I think I should repeat that. So the strategic water source areas were described as being 8% of our land, which actually provides 50%, half of our fresh water. The Mabola protected environment was identified as incredibly important and strategic to protect the interests of all South Africans. So soon after the declaration, a mining right was granted to an Indian-owned company called Other Africa Ventures to mine properties within this Mabola protected area. So before a mining company can commence with any mining, there's certain authorizations that it ought to have. So I'm just gonna name them: a mining rights, environmental authorization, environmental management program, a water use license, a zoning certificate to actually be able to mine in the particular area. So the company has been granted all of these authorizations except for the land use change approval. And the CR, on behalf of 8 civil society organizations, challenged all of these authorizations. So ordinarily, these are the only type of authorizations that a mining company would need to have. But because this is a mining right that is granted in terms of a protected area, there's an additional authorization that the mining company needs to have. And that is in terms of this act that I was talking about, which is NEMPA. This act says that the the mine has to receive written permission from both ministers, the Minister of Environmental Affairs and the Minister of Mineral Resources, for it to be able to mine in that particular area. So the coalition, the civil society organizations that are represented by CER, made various attempts to kind of get information in relation to these permissions. So they addressed so many letters to the Department of Environmental Affairs asking whether such an application has been made to the ministers, whether both ministers have actually spoken or there's any correspondence between them talking about these permissions, and whether there was any public participation that took place in relation to this application. But unfortunately, we were unable to obtain this information. The information is actually refused because the department said we actually have to make use of a process under the PIA, so the Promotion of Access to Information Act. We couldn't get it directly, but we had to use this process. So that's exactly what we did. We had to submit a number of PIA requests, requesting this information that we've been addressing in correspondence. Shockingly, we did not receive this information through this process. We only got to realize that these permissions had been granted in relation to a document that relates to a water use license, so something very unrelated to the NEPA permissions. To add, there was no public participation that was conducted in relation to these permissions. The Minister of Environmental Affairs even says publicly in newspapers that there was no need for any public participation to be conducted in relation to these permissions. But the Act specifically says that in applying this provision, the ministers ought to take into consideration the interests of local communities. So this was inadvertently violated. So when we looked at the reasons that the ministers gave when they said they granted these permissions, and the ministers based their decision on the fact that the mine has already obtained all the authorizations that it needed to mine. So that was their basis for making the decision that means everything was in order. If they granted all these other authorizations, then it's fine. Then we can grant the permissions. The minister also based a decision on the environmental impact assessment reports that were submitted by the mine. They said that there were enough mitigation measures articulated in that particular report for them to come to a decision of granting the permissions. However, this report that they relied on was actually rejected by the department, so they relied on an outdated version of the environmental reports. The mere fact that the ministers relied on, as I said, the report that was outdated, and the fact that they relied on other authorizations to come to a decision actually means that the ministers did not apply their minds when they were considering these applications. It means that they did not exercise an independent, fresh discretion in terms of this application, in terms of NEPA itself. And because this is a protected area and the mining rights been granted in a protected area, there ought to be some exceptional circumstances that warrant the ministers to actually grant the mining rights in this area. Because there's a reason for areas to be declared as protected, right? So if they're not gonna really scrutinize the applications, then what is the reason for declaring these areas as being protected? You might as well just not declare them at all. Some form of maybe other kinds of mining may take place in protected environments. But we know that coal mining is very intrusive and hazardous and can have very negative impacts on the environment. So as a result of this, the civil society organizations that we represent decided to take this matter to court so that the decision of the ministers is reviewed and actually set aside, because it is quite clear that they did not exercise their discretion in relation to NEPA, and therefore these decisions are unlawful. So the ministers did not give effect to Section 24 of the Constitution as they were mandated in terms of NEMPA?
So despite all the many laws that we do have and that we've spoken about today, there are still some holes in our legislation that prevent the law from truly having green fingers. So in 2015, the Centre for Environmental Rights produced a report called Full Disclosure, The Truth About Corporate Environmental Compliance in South Africa. And we updated and expanded this report in 2016. Now, this report looks at what companies say about their non-compliance with environmental laws. So, in other words, if they've breached environmental laws, do they disclose this to their shareholders in their annual reports? And then we compared what the companies were saying to other publicly available information. So, for example, every year the Department of Environmental Affairs produces a report which sets out the inspections that they've conducted and the findings of some of those inspections. So we were seeing that you see one side, you see what the Department of Environmental Affairs says. It says it inspected AMSA, it found multiple non-compliances, and then you look at the same year for AMSA's annual reports and they say nothing to their shareholders about this. So they're not disclosing their breaking environmental laws to their shareholders. So we have to ask ourselves, why don't they disclose this? So we looked at the listing requirements. What are they required to tell their shareholders? And they're required to tell their shareholders material facts. So the companies are not regarding their breaking environmental law as a material fact. So it's not material to their shareholders. And the reason they don't think it's material is because they never get fined for this. So they don't get huge fines when they break environmental laws. And because they don't get huge fines, they don't feel the need to disclose this to their shareholders because it's not affecting the bottom line. So we put this together in a report and we explained these discrepancies and these problems, and it made us think, what would better the situation? So currently the regulators, they can go to these facilities, they can issue compliance notices, they can issue directives, they can tell the companies to do certain things, but they can't go inspect and then issue a fine. They don't have that power in law. They don't have a power to just issue a fine or even to go through a short process like we tell the company that this is the fine we're going to issue you, we give you one opportunity to give us your representations, and then you get fined. They don't have that ability in law. So they can do all their compliance notices, the directives, and then if the company still doesn't comply, all that they can do is they can issue a criminal complaint. And then that criminal complaint has to get investigated. It has to go through the criminal justice system where there's a huge onus, a burden of proof, where they have to satisfy the court beyond unreasonable doubt that this company did X, Y, and Z and it had this impact on the environment, which is very difficult. So we see very few instances where companies have actually been fined or had to pay huge fines for their environmental non-compliances. And this means that they don't regard these laws as being very important. They don't regard it as something that they need to tell their shareholders when they breach them. And this is always going to be a problem until it is rectified with additional powers to our regulators. So just in conclusion, does the law have green fingers? We've seen that the law has many green fingers. We have an excellent constitutional right. We have a host of laws that are designed to provide a range of protections. But we often see pitfalls at the implementation level. This is sometimes a result of deliberate attempts to circumvent the true purpose of these laws. So we know what the purpose of these laws is. We know that we're supposed to take into account social, environmental, and economic factors, but we see that circumvented. Is that because it's a deliberate attempt to go around the law, to go around what the law actually says? Sometimes it's a deliberate attempt. Sometimes there's capacity constraints within departments, so they don't have the manpower that they need to go and investigate all of these facilities. And sometimes it's a result of not having the right tools. So when we spoke about not having the ability to actually issue the fines that they would need to issue to make companies really stand up and take note.
So we are really seeing that more and more environmental justice litigation in the courts. the court seems to be more sympathetic, especially towards organizations, environmental justice organizations. We can see this from the quotes that we read out for you guys. The judges recognize that civil society organizations should be included in processes that actually might affect them. And the judges and the courts also have said that they should have access to information and weigh this into the extent in which the developments are likely to affect them.
We just want to tell you really how exciting environmental law is. I know it sounds cheesy, but it really is an exciting area of the law. It's constantly developing, it's constantly changing. We're seeing shifts in international and local thinking, which is impacting the way we interpret and use the law. We're seeing that there's definitely global changes. People are understanding that we can't continue with business as usual if we want to avoid catastrophic climate change. And because of this shift in thinking, the law is becoming even more critical, and our environmental laws are becoming more used, better interpreted, better applied, and it's because we're starting to see a shift in political will. So I just want to urge you, if you're considering a career in environmental law, it really is an exciting aspect of the law. It's not like contract that hasn't changed for decades and decades. It's something that's constantly developing, and we're seeing new precedents every day. So yeah, thank you very much for having us today, and thank you for your time.
Okay, so has anyone got any questions? I think there's a mic that will come around. I saw at the back and then in front. Did you have a question? Yeah? And then you, and someone was over there. This gentleman was over there.
Hi. So I'm doing my research on the implementation of environmental laws at mines. Basically, I'm looking at the one environmental system. And I've looked at a few documents by the CER, and most of what I've read basically advocates for the Department of Environmental Affairs to be the implementing authority of environmental laws at mines. Based on your presentation, I've noticed that the DEA has made quite a few blunders, and they have gotten quite a few things wrong. So what makes you think that the DEA will do a better job of implementing environmental laws at mines than the Department of Mineral Resources? Thank you.
Yeah. I'll just answer the first part and then Christine will take over because she does this mostly. But we are basically saying that it's better if the Environmental Affairs looks at environmental issues rather than the Department of Mineral Resources, who actually has a mandate to promote mining and also have like environmental considerations. So it really doesn't play out well because obviously the DMR would want to kind of lean more onto the development side, and then you find that environmental issues are not prioritized. So if you have a department that specifically looks into environmental issues, you have more confidence that they will actually really consider them. But I'll just let Christine carry on from there.
Yeah, so exactly as Tobek has mentioned, it's a mandate issue. So we're not saying, I mean, none of us in the sector would say that the Department of Environmental Affairs is perfect. It certainly isn't. All government departments have their challenges, but the Department of Environmental Affairs has a specific mandate that's determined in terms of legislation, and that mandate is to protect the environment. That should be their primary goal. Whether or not they always do the right thing is a separate discussion, but that's their primary mandate. Whereas the Department of Mineral Resources, they're about promoting extraction of minerals. So to give them that, to then expect them to go onto mines and that they've had this relationship with, and they've built this idea about this is good for the economy, extract minerals here, but at the same time then they have to regulate the environmental impacts. It's just a complete conflict with their mandate, and it'll prevent them from doing that job properly. And we've seen that. So the One Environmental System has now been in place since December 2014, and we really haven't seen the Department of Mineral Resources step up to the task. We haven't seen them investigating mines, we haven't seen them instituting any prosecutions yet, and it was certainly, the mandate was never with the Department of Environmental Affairs, to be fair. This is something that's always been with the Department of Mineral Resources, but before the One Environmental System, the Department of Environmental Affairs had a bit more power in terms of the so-called ancillary activities of the mining. But it's very disappointing that that shift didn't happen, and the shift was contemplated when they started these negotiations, the shift to the Department of Environmental Affairs, because now we're sitting with a situation where the Department of Mineral Resources really just doesn't seem to have the political will to go after these companies and to get their hands dirty and to make enemies of the mining companies. They want to be friends with the mining companies, whereas the Department of Environmental Affairs definitely had been a bit more bullish in when they had certain powers or more powers before the One Environmental System, and I think they would have taken up that role a lot stronger if the handover had happened.
Yeah, you guys have been hit by the recent defamation suits, and I just wanted to know what the effect has been on your work, whether it has impacted, and like what you foresee the impact to be. Thanks.
Cool, I'll take this question because I'm defendant number one. In January this year, another colleague and I gave a presentation here at UCT for the summer school, and we spoke about a particular mining operation and their impacts on the environment. And then a few months later, we were served with a defamation suit. So with quite a hefty penalty. But we're defending that, and we've got the full support of the CER. They sued us in our personal capacities, but we're part of an organization that sees the value in freedom of speech and in fair comment and in the truthfulness of what we said. And as long as we continue to speak based on facts and to give fair comment and fair opinion, then we will continue to do that, and we won't let it stop us from giving presentations like this, talking about specific mining companies, because that's our constitutional right. And we will be in court, hopefully next year, and hopefully we'll get some great precedent out of this and use it as an opportunity to shine the light on these kind of tactics by companies going after people in their individual capacities, and we'll get some good precedent around what it means to be able to speak in public forums like this, academic debate, freedom of speech, and yeah, so we're looking forward to it.
Thank you for the talk, it was very informative. Well, this defamation has actually added a bit of fuel to my question. You hinted at in your talk really two main problems that I see. We have, first of all, a government that is obscenely corrupt, and as a carte blanche report recently showed, they're even stymieing the very promising renewable sector because they're committed to the ESCOM growth model, and of course the nuclear deal from Russia that's just to line the pockets again of our parasitic rent-seeking elites. But then the other problem is with, and that's not just unique to South Africa, is we're committed to an unsustainable infinite growth capitalist system where between protecting environmental rights and protecting profits, the latter will really always win out. So I see the law is certainly very important, and your organization is doing great work, but aren't you always kind of a thimble for, pouring water out of a sinking ship? Or it's without a total socioeconomic transformation here and globally, I just don't see the law as being able to really protect environmental rights, because all mining has to stop. For instance, all coal-fired power plants should be shuttered. I mean, that's really what it means to be sustainable. So it seems like when you talk about a sustainable or a clean coal, there's no such thing. There's no such thing as sustainable nuclear, all of these. So I don't know. I know maybe that's beyond the remit of law, but it just seems that you're always going to have this problem.
Okay, maybe I'll start, and then our executive director can jump in, because this is a hard question, and that's why she's here. I think you've got to pick your battles, and I think that's a very pessimistic view, and I get it. I get that view. We wouldn't be here if we thought it was hopeless, and if we thought the law didn't have any role to play. If you look at the Thabo Mbeki judgment, for example, and you see the kind of the thinking that the judge is applying to these sort of scenarios. The company said, oh, but the applicants are just trying to stop coal mining. That's what they're trying to do. This is like a disingenuous attempt just to stop coal mining. And the judge said, well, actually, if that's what they're trying to do, it's not really that illegitimate, because maybe we should, he didn't go so far as to say maybe we should stop coal mining, but he definitely got it. And we're not saying that all mining has to stop. I mean, there's certain projections about how much needs to stay in the ground so that we don't go over the 2 degrees global warming, and then we keep things manageable and we don't have catastrophic climate change. So it's not necessarily the case that all mining has to stop, and we don't necessarily think that. The mining that is happening needs to be regulated properly, it needs to be mitigated properly. We certainly don't think there should be any new coal. There's no reason for new coal. So we're campaigning to stop new coal and to plan for a future without coal, so to slowly build up a situation where you can shut down the existing coal plants. But that transition obviously takes time. So we say a just transition and no new coal. That's something that's workable, and that's something that I think the law supports.
It's such a tricky question, and it really is a question that we struggle with. Ultimately the law is obviously an instrument of people. It's an anthropocentric tool. I don't think any of us are naive enough to think that we can shift that fundamentally through the legal system. I mean, there are lawyers who write about this stuff, approaching the law in a different way. I see Professor Gladzewski sitting over there, could maybe comment on that. But ultimately, what we do see is a trend. And that, I think, is quite encouraging for us, and we could see how our colleagues in other jurisdictions have used the law effectively to slow down and to get rid of a lot of coal. In the US, that's turned around completely, and we see similar shifts happening in places like China. You never thought that would happen in India. So, I think as human beings, we're always tracking a little bit behind what the Earth actually requires, or a lot behind what the Earth actually requires. It's still work that's worth doing. And we work within a particular framework. We're constantly trying to improve that framework, but ultimately, as I say, this is still a human framework that we're using, to engage with nature. And I don't see that changing anytime soon, unfortunately.
I was going to comment earlier on the question from the back here about enforcement and that, but now that other bigger issues have been raised, but I want to come back to that. Firstly, about the defamation, I just want to make a general comment that it's quite common with powerful corporates in America here to try and legally bully the little person in what they call slap suits by hitting exactly what's happened here and to use money to force you out of what you're doing. So it's a common tendency worldwide in the environmental field. That's just a general comment. And to come back to this discussion now, what went through my mind when you asked your question here, or made your comment, was when I was a law student, then it was obviously heavy apartheid, states of emergency, and there was only a small handful of lawyers that were fighting the fight. And generally a lot of people say, oh God, we can't fight the state apparatus, it's just hopeless. We can't do that. There was just amazing how a few small people led by the Legal Resources Center made big changes. So we can have an ongoing thing about that. But now just a practical thing to come back to your question about the environmental management system, and an important role is being played by the Green Scorpions, which are under the Department of Environment Affairs. They were only established in about 10 to 15 years ago as enforcement officers. And what my question, and they're known as environmental management inspectors, and they reside under Environment Affairs. But now I've got wind, and I'm not in the real world at the moment, I'm up here, that the Minerals Department has what I thought were so-called brown scorpions, but I'm told by Phil Snowman there's no such term. But he told me about EMRIs, environmental management. So can you explain to me, what is the relationship between EMRIs and EMIs? Because it's related to her question there. Thanks.
So, yeah, there are environmental management resource inspectors, your emeries, and they, as far as I know, they're not directly related to the environmental management inspectors. So you have the green scorpions, they do their thing. I think they try to train, sometimes the Department of Environmental Affairs tries to help out with the training of emeries, but I don't know if they ever take up the offer. What we've seen in our cases is that there's not enough environmental management resource inspectors that have been appointed. So, for instance, in one case where we laid criminal charges against a mining company, post one environmental system, and then we were told, okay, this is not a job for the green scorpions, this is now a job for the emeries. Then we were told that the environmental, the regional manager in Limpopo was the guy who was an emery, and he was assigned to deal with this case. So you have a regional manager, which is a very high up position, who's got 1 million demands on his time, and he's now the dedicated EMRI who's supposed to investigate these criminal charges. And those criminal charges were laid in May 2015, and we're now in 2017, and nothing has happened. So I don't think there's much movement with the EMRIs. Yeah, Melissa can maybe add if she's got anything to add, but they exist. They've been appointed.
Under the minerals department.
Yeah, minerals.
So an interesting little story about that is that when the One Environmental System was designed, the idea was always that they would be environmental management inspectors just like all the other ones, and that they would form part of the inspectorate. And then when we saw the resource inspector appearing in the name, we assumed it was because they wanted to keep themselves separate and they want to be part of that. And when we asked the green scorpions about it, they said no, they don't want them to be part of us. So there's a quite a difficult relationship, obviously, between. But it really is reflective of that mandate problem that Christine was describing earlier. When you've got a department that really is there to promote mining and call mining companies their clients, a great source of frustration for the attorneys at CER. And then people who ostensibly are there because of an environmental mandate. So, but we have grave concerns about the rollout of the One Environmental System. We don't see any real intention on the Department of Mineral Resources, despite the training that they've done, to actually do any enforcement. So in the near future, we are going to be forced to reconsider this position, because we're now in a situation where there is effectively no compliance and enforcement of mines and the environmental impacts. That's literally where we are at the moment. It's as severe as that.
Just a quick related one. Does Water Affairs have an inspector division as well?
Yes, the Department of Water and Sanitation, they have the compliance monitoring and enforcement unit. Similarly, there are not a lot of results coming out of that. We track this very closely. So we submit PIA requests, we follow questions in Parliament, reports by the departments to the portfolio committees, and we really see very little actual action. I mean, compliance enforcement is not an easy thing to do. It's always difficult. You've got to have people with the right skills, and it's a different type of skill. Some is criminal enforcement, some is civil, legal background. So, there's huge scope. I mean, I look around the room and people, lawyers, it's a fantastically interesting sphere to work in, but we really need to see much greater political will from the politicians to make this happen and support for it, Not to see it as a threat to development or industry, but to see it as a way to mitigate the impacts of that, in the long term.
But I want to come closer to home. We talk about environmental rights, and then we look at what is happening at the local government level. And here we're not talking, I'm not going to go into the world of work where you have what some people call the trolley brigade, people walking around picking up dirt or whatever is usable from bins and then selling that off wherever, either at the municipal depot or at some recycling plant. But I'm sure much more can be done. What are you doing to persuade municipalities or local government to install, hopefully at each and every home or each and every earth, three different sets of disposable containers, perhaps one for glass, one for plastic, one for whatever the case may be, and develop a sense of consciousness on the part of the ordinary citizen that environmental rights, yes, may exist in law, but how we as citizens of this country engage with the environment ourselves is of fundamental importance to realizing those rights that exist in law. And I'm simply posing the question, what work is being done in that regard? Thanks.
Thanks for your question. Tricky question. So, to be honest, we're not doing a lot at the local level about the sorting of rubbish or any sort of campaigns around that. We don't have specific programs dealing with that. We're a new organization. We've been around for 7 years, and we've developed, as I mentioned in the start, a set of programs. And we really focus at this stage, given our manpower and how many people we have, we focus on strategic litigation, high impact changes to the law, and our advocacy work. We do definitely do a lot around the promotion of environmental rights, getting people to understand their environmental rights. We've started running various training programs for local communities, getting them in, explaining the law, explaining the constitution, explaining their powers. So what can they do when there are environmental violations in their area? How can they report that? How can they follow up with that? What tools do they have at their disposal at the very local level? So there is a lot of that we're doing around the training. Yeah, I think that's all I can say on that.
Yeah, Christine is right. I think there's a lot that we would like to do as an organization. And even with the work that we do right now, we find that we do not have enough capacity. So capacity is sometimes a very big issue when it comes to these things. We would like to do work like that, as you mentioned, but we really are sometimes really struggling with capacity, and you would find that there are not a lot of environmental organizations in any case in our country. So as Christine said, we are trying to really capacitate local communities in terms of knowing their rights and how they can enforce their rights so that they can also disseminate that information that they have and use it for themselves and their community members. But yes, we do agree that there needs to be work that can be done in that level.
Hi everybody. Thank you guys so much for the talk. And I am not a lawyer, so when I'm in such spaces I get nervous about it. But I'm actually a master's student in the Environmental Humanities program. So the center of our whole learning is around the environment. But I think it's very important to kind of recognize the work that civil society and organizations such as you, who are basically the only constituents who are actually calling out people like corporations and being the watchdogs for in the environment, because we know for a fact that the government isn't, right? And so the Constitution of South Africa, yes, yeah, I have a problem with that. And I think already mentioned how the Constitution is very kind of problematic in its own right, particularly when it relates to environmental laws. And I think it was mentioned that for one, the Constitution is one which is centered around people and not the environment. So that's the first thing we need to challenge. So why is it that the Constitution is only prioritizing people instead of the environment? And there are countless countries which, are doing other things. So we have, Bolivia for one, has a whole constitution and has basically given rights to the environment. So it has placed the environment in the same kind of playing field as humans. So I think then a real question we should be asking ourselves as environmentalists is, and I guess it's an ontological question which is at the root of all environmental kind of people, is so how do we see the environment, right? How do we understand the environment in the current time? And I guess being, in a capitalist kind of way, the environment is for capitalist gain and profit, basically. And that is, I mean, there's no getting around that. So that's a problem we have to kind of encounter as environmentalists. So we implicate it, basically. But I guess the question then is, can the Constitution of South Africa kind of change its approach to its law? And I guess imagining the environment and nature as human, as living, as breathing, right? That needs rights, that needs protecting, and not just humans granting human rights, right? So a deeper ontological question is the question of the environment and what it means now. And I think it's very important. And it's, I guess the work we're doing is of urgency, right? We are at that critical moment on the earth where it's just giving up, it's over. So, but, yes, so, but also I just have a question for you guys. So the Department of Mineral Resources, right? So the minister, I don't know who he is or whoever the person is. Yes, that person. So he, correct me if I'm wrong, so he's responsible for issuing out mining licenses to mining companies, but also the Department of Mineral Resources is also then also responsible for policing the environment. So just look at the ethical dilemmas there. Already that's a problem. The Department of Mineral Resources is issuing the licensing of mining. I'm just gonna put it out there to like think about that. Already that's just not good. It's ethically that's not. So just your opinions on that, and I guess because a lot of your work is centered around corporate violations and mining, and I guess why I follow a lot of your work is because of the work you do in helping mining communities and giving them, speaking for them. So just your thoughts on that.
Yeah, so I mean, we've talked a lot about this conflicting mandate issue with the Department of Mineral Resources. So yeah, they're responsible for issuing the mining licenses. Even worse, they're responsible for issuing the environmental authorizations. So, and for considering the environmental management programs and considering all the mitigation measures that the proposed mining operation puts together. So yes, they're responsible for all of that. And yeah, I mean, at some point, this is a battle that we fought before it became law. So before the One Environmental System, this is something that civil society campaigned very, very hard on, something that the Centre for Environmental Rights was submitting questions to Parliament, was actively campaigning against this happening. But despite all of our efforts, we've ended up with this being the law. And I think we're going to have to think critically and carefully around whether we challenge that, even now that it is law. But perhaps we need a few more years of evidence building, of showing that the Department of Mineral Resources is really not able to fulfill this role, get the evidence together, and then challenge it. You know, maybe that's something that we have to do. I think at this stage it is still early days, but we're definitely not seeing anything from the DMR. We're not seeing them come to the table. We're not seeing them investigate. But yes, I think we need to carry on getting the evidence together. Then just on your constitutional point, maybe I can just... So yes, there are certain constitutions in the world now, not many, I think only maybe one or two, that have introduced this notion of the earth having its own rights. So our constitutional right, like you say, is based around from the human perspective. So we have a right to an environment that's not harmful to our health or well-being. So it's intimately connected with people's health. And some of the other constitutions in the world are moving towards this notion that the earth itself has its rights. Yeah, it's a very interesting concept, and it's definitely got its pros. I don't know if you know Cormac Cullinan, who's written a lot on this issue. He's got a book called Wild Law that really explores this notion around the earth, giving earth rights. I think our constitution, though, I mean, I don't think it's fair to say that it doesn't recognize the environment and it's all about people, because I think we do have a strong environmental right. And some of the things, the debates that we've been having in the office over the past couple of days is whether we're sort of hindered from approaching this right directly because of all the legislation that we have and all the processes that we need to follow every time there's a violation and a contravention. And we're not getting direct access to this right. We're not getting a lot of cases around the right itself and how far it goes and how far it can stretch. So yeah, that's another thing to consider in our litigation strategy about how we push the boundaries of that constitutional right itself.
But it seems to me, so with the Earthlife judgment and the Mabola case and all these various cases, improvements in the law seem to be done on a case-by-case, piecemeal sort of basis. And I was just wondering if you guys were doing it, because I know you guys do a lot of policy work as well. If you'd, I don't know, we're looking at any sort of regulation or code improvements that include these considerations that should be included, like consideration of climate change as like a mandatory, I don't know, consideration, or yeah. So obviously it will be now because it's because of that judgment, but other considerations, other anticipated considerations. So I was just wondering if you guys are doing any work on that. And then secondly, I think in the last 5, 6, 7 years that you guys have really been on the scene, you've like quadrupled in size or something, and or something like that. So I just wanted to how that was done, and whether you have any advice for other public interest firms that are doing similar sorts of work maybe in other fields. Thanks.
Thank you for your question. In terms of the policies and stuff, we do comment on a lot of legislation. So when draft bills are sent out, we do a lot of work where we provide our comments where we think that the law needs to be changed in certain instances. So we do work around that when we comment on legislation. Sometimes, well, most of the time our comments are not considered, but sometimes we do get them considered. But in most cases they are not considered. But we do always try to comment on all the relevant legislation that we think are relevant to our work particularly.
Maybe just on the growth question, I mean, I think that's more a question for our executive director, because I think, yes, the CEO started 7 years ago, and it was, I think, 2 people in the beginning, then 4 people, then it's slowly grown, and we're now, I think, 24 people in total. I think part of the reason for that is the niche that we fill, the fact that there aren't environmental justice NGOs like us out there. We're one of a kind in a way. There are other, I'm not saying there aren't others at all, I mean there are other NGOs working on environmental rights issues. There's other legal clinics that have environmental departments, but I think we're quite unique in that we're lawyers, so we're a law clinic and working on these environmental justice issues, and that gives us a lot to do and a lot of scope. I think there are a lot of funders. We're completely funded by philanthropic organizations. We don't take any funding from corporates. And I think there's a lot of those philanthropic organizations that get this. They understand the importance of the work that we do, and they're willing to support us and help us grow. So a lot of thanks needs to go to those organizations for their support that have allowed us to grow so quickly over the past 7 years. And I think we're very responsible in the money that we get. We don't take it lightly, the fact that they choose to invest in the work that we do. We report on the work that we do. We're very open with how we use the money. So I think that's an important aspect of why we get repeat funding and why we're able to do what we are able to do.
Talk a little bit more about your wider strategy of working, particularly with affected communities in the areas that you're doing kind of more legal kind of strategic legal intervention. So what are the other ways in which you engage with communities more broadly, affected communities in particular, beyond kind of formal legal cases? And that links to the issue of, I suppose, community mobilization, because I think you're seeing increased mobilization in areas that are being dealt with impunity in relation to environmental rights. So just some reflections on that. And perhaps linked to that, I'm curious to know, kind of moving forward, where you think there might be or already are intersections with other organizations that have a broad interest in social and economic justice. So I'm thinking particularly the intersections between environmental rights and spatial justice, some of the very exciting activism we've seen in urban areas around urban development and issues of spatial violence, and then the intersection with health. And what possibilities lie there in terms of, I suppose, bringing issues of environmental rights into closer conversation with issues of social justice more broadly. Thanks.
We do try to engage with a lot of mining affected communities. Like we said before, we conduct a lot of training for certain of the activists. So those activists are trained, and then they can take that training and go back to their communities and train the members in their communities. So we try to do it in that way, because we cannot always be everywhere at one time, because we are a small organization. So we do try a lot to capacitate people who are already in the struggle, and then they can kind of go out and also capacitate their own communities. We also work with a lot of partners who deal directly with mining affected communities, such as Groundwork, and they sometimes call us in as well to provide like legal advice and legal expertise in that relation. So we also have access to these communities through our other organizations. We also have a organization that we helped establish, which is called the Mining Environmental Justice Network of South Africa. This organization deals directly with mining affected communities, and we have a steering committee that we engage with a lot, so that, like I said, they as well try to capacitate their own community, but we do work a lot with mining affected communities.
Yeah, and we also, there's also a lot of coalitions in this space. So, for example, there's the newly formed Life After Coal campaign. So that's with Earth Life Africa, with Groundwork, and with the CER. So it's strategizing around a joint campaign to try and, move towards this just transition to renewable energy. And we've got other coalitions like that. We've got an Access to Information network where we all meet twice a year to deal with our information constraints, and so there's definitely a lot of networks and intersections amongst the environmental justice, but also the other social justice organizations in South Africa. On your issue about intersections in terms of spatial justice and health, I'm not sure if we do much in terms of spatial justice or anything, but we definitely, health is definitely a big issue on our radar, and we see that intersection all the time. For example, there's areas such as the high fault priority area where you're supposed to have specific regulations to try and bring the pollution in that area, the air pollution in that area down, and we've done a lot of work around what's happening there, or more like what's not happening there and what needs to happen there. And that's an air quality issue, but it's also a health issue, and we definitely draw that connection and that intersection a lot. And that's also how we get people to take note sometimes of environmental issues, when we can connect it to health, and we can say this is actually affecting you specifically. And sometimes people living in the area don't even draw that link, so they might be suffering from asthma or nosebleeds, but they don't think of it as an environmental concern. So to draw those connections, very important also to get them on board and to help them as well when they see it from that angle. Yeah.
Okay, I think we're probably going to have to close this session today. I just want to say a huge thank you to Christina and to Becca for really insightful reflections on your experience in practicing environmental law. Big thank you as well to the audience. I think sort of your comments and your questions it really drives the kind of conversation that we want to have with this Without Law Conversations. So thank you very much. and we have a few tokens of appreciation.
Thank you very much.
Thanks
Yes.
very much.
Sorry, just to mention that we will be having our next Without Law on the 5th of October. We'll be hosting former Chief Justice Moseneke and the ELC Law Clinic as well. We'll be advertising and sending out posters and invitations close to the time.